Next case is State versus Redmyer. Good morning. Each side will have 15 minutes, and you as the appellant may reserve up to 5 minutes. If you so choose, just let me know and I'll keep your time.
Thank you, Your Honor.
Thank you.
Attorney Sean Buchanan on behalf of the appellant, Mr. Matthew Redmyer. As I'm sure this court is getting used to, I don't have a watch, so I have my phone out and I'm checking my email. That's how I keep track of my time. Specifically in this case, I'd like to jump ahead to assignment of error number 2, as I believe it is the most important. The record at sentencing does not indicate that the judge made the required findings as to 2929.14 for the imposition of consecutive sentences. The judge does indicate that she had made some considerations, but the record at the sentencing itself, transcript, indicates that that was in consideration of whether or not to impose community control and was geared towards the community control factors. The subsequent entry in this case did indicate consideration of the consecutive sentencing factors, which are somewhat different, but the fact that those were not considered as sentencing is not fixable via entry. I believe that is the holding of Medina, and I believe that is supported by the subsequent case law in Mill versus Spears, or Mill and Spears rather, but there is some inherent leeway for the court to examine the record the appellate court to examine the record as a whole and see what it was the judge was thinking about without requiring that they say magic words or talismanic words, as the court refers to. And I think that is important to address because we do still make those type of requirements of judges all the time, and that they, in essence, are required to show their work. And I believe that that's a valid requirement by the legislature, that judges do show their work, and frankly that they do it in open court, because I think in addition to the requirements being of benefit to the judges, and that it's an opportunity to review, it's an opportunity to say what it is you're doing, it's an opportunity to go through that checklist and make sure you're doing what you have to do, even if it seems kind of annoying. I think you can ask surgeons whether or not they think they're smart enough that they should be able to skip their pre-surgery checklist, but they do it every time. The fact is, we are human, we have human brains, they are subject to error. I know myself, I like to repeat my grocery list as I get out of the car when I've reached the grocery store, rather than relying on my memory there. And I think that's important, that the judges essentially have to make similar steps. And I think there's an inherent dignity in our process that we do these things at the sentencing. We do it when the defendant is there, we do it when the judge is there, we do it when the lawyer is there, rather than doing it by entry. That's one of the fundamental precepts that separates the American system from a star chamber, in that the defendant has dignity as a person, and he gets to know why it is that he's being sent to prison, and why it is he's being sent to prison for as long as he is. And I think that's a fair requirement to place on judges, and I think it's obvious by 2929.14 that the legislature has chosen to do that, and the Supreme Court has upheld the decision to do that in Medina. In addition to that, a close reading of the record indicates that the court's consideration of the factors relates to probation, community control. Once again, not the consecutive sentencing, and the sentencing scheme is a 2-level sentencing scheme in Ohio. It's, first of all, are you a good candidate for community control? Client, well, the defendant in this case was not. The court made that finding. We have no issue with that finding, and we think it was done properly. the court then has to do another additional analysis and go, well, if you're not subject to community control, are you subject to consecutive sentencing? Nothing in this sentencing hearing indicates at all that the judge in this case viewed those two things as separate things. And the legislature has clearly laid out that they are separate things. They are not the same thing. If somebody's not eligible for community control, we can automatically put them on consecutive sentences is something that is unsupported by the code and unsupported by appellate decisions. The second aspect of this case that I would like to note is the third assignment of error, and that's the joint and several liability. The judge indicated in this case that the defendant was responsible for $75,000 of restitution with no offset for any amount that the co-defendants pay. There are two co-defendants in this case. I don't think I'm saying anything that's a surprise. The payments in restitution cases where people are sent to prison are theoretical payments. It's not something that we have a huge practical emphasis on. And I don't think the victims in this case are going to end up with $150,000 worth of restitution, 75 from my client, 75 from one of the other co-defendants. But at the same time, this is an entry of the court. It is required to be specific, and it is not something that can simply be left to the clerk to sort out. If we do take the position that the clerk can sort out joint and several liability and impose it in cases where it is not in the record, it completely precludes the ability of judges to order differing amounts of restitution to co-defendants.
What is in the record of this case showing us that restitution was ordered in the co-defendant's case?
I cited to the decision in the co-defendant's case, the entry and
that's in the record, though?
I cited it in the brief. I did not file. I don't believe I filed a supplemental authority introducing that judgment entry itself. But regardless of that, the defendant's liability still should have been joint and several, because it is clear from the record that there were three co-defendants in this case, and that all three co-defendants did receive a sentence.
3 or 2?
I apologize. There were 3 total, so 2
Okay.
co-defendants. And that essentially, if we let the clerk impose joint and several liability when it's not in the record, there's no way to ensure full liability in differing amounts if a court were to order it. And I think it's important to note in this case, the record of what the court ordered was not in any way meant to be distinguished, because the victims in this case came in and testified to their total sum of damages, and the court apportioned total sum of damages pursuant to the victim's testimony to the defendant in this case, which I believe he is entitled to joint and several as a responsibility. I do believe, because of the nature of that this would be one of the limited areas in the criminal law that I think a non-pro-tunc could be appropriate. So I don't believe that a remand on this issue alone would require a full sentencing hearing, because the restitution operates as the imposition of a judgment entry, and in many ways is almost a more civil process than a criminal process, especially if it's not made a requirement of probation or something like that it be paid, which it was not in this case. So I would, and then briefly like to address the first assignment of error. I believe that this case is distinguishable from the other cases where burglary and the thefts themselves are not found to be allied offenses, because in this case, the specification that accompanied the charges was essentially identical, and that differentiates them from the burglary and theft cases where they don't have the same level of elements that go together as a similar act. I think it is kind of a stretch to allow the state to say, well, it's the same conduct for the purposes of the specification, but it's not the same conduct for the purposes of merger. And in this case, especially with, I believe, counts 1 and 4, the specifications line up identically, and then in the other 2 counts, the dollar amounts line up identically. So I think that these cases can be distinguished between, this case can be distinguished between those that do allow for non-merger on burglaries and thefts. And I would ask that the balance of my time be reserved for rebuttal.
You did really well, in just a little over 5 minutes. Thank you.
Thank you, Your Honor.
Thank you, Your Honors. I am still Matthew Kern on behalf of Dean Holman, the Medina County Prosecuting Attorney, and I represent the state of Ohio in this matter. I'd like to take the assignments of error, I guess, in the same order that Mr. Buchanan has this morning. I guess that means we'll start with the second assignment of error with respect to the consecutive sentence findings. Now, the argument you hear this morning is that judges have to show their work. And although I agree in some principle, I disagree with the implementation. Specifically, although judges have to make findings, they don't have to give their reasons in support of those findings. And that comes straight from the Ohio Supreme Court in that State v. Bennell case that counsel's citing. So if the court doesn't have to give its reasons, it doesn't have to explain why it's making its findings, it just has to make the findings. That's enough. If there's a basis in the record to support those findings, the court doesn't have to explain it. The court doesn't have to show its work. This isn't long division. The court just has to make the findings. That's sufficient. It makes the findings at the hearing, and it puts those findings in the entry. That's all that Bennell requires. Then the second part of this that the counsel argues this morning is that really there's a bifurcated two-step process when imposing sentences on these kinds of offenses. You have the first question, whether there's community control or prison is appropriate, and then a second question, if prison, then are consecutive sentences required. And respectfully, counsel's argument kind of misses the legal requirements. First is there are no findings requirement for imposing a prison term, although 2929, 11, 12, 13 all give the trial courts a number of factors to consider. None of those are findings that the trial court has to make. So when the trial court goes through and says the need to protect the public from future crime, punish your actions in this matter, and that they are not disproportionate for custodial incarceration, at sentencing transcript page 29, the court isn't making findings in support of a prison sentence versus a community control sanction or versus a residential community control sanction. The court is making findings for consecutive sentences. That's what's required in this case. So the court has determined that a prison sentence is appropriate. The court doesn't have to give findings in support of that. So there's no two-step process, as counsel would seem to indicate. On a theoretical level, I understand the argument he's making. Yes, you first have to decide if prison, and if prison, then the other. But there are no findings required for that first step. So when the court's making findings, the only thing it could be making findings in support of is whether consecutive sentences are appropriate. And so when the trial court goes through that, there's no question that the trial court made all three findings. That's typically what this court is seeing in consecutive sentence challenges, right? The State v. Mills case and the Spears case that counsel's referring to are about whether the court actually made all three findings at the hearing. There's no dispute in this case that the trial court did. The trial court says that it needs to protect the public from future crime and punish the offender, and it talks about the disproportionality or lack thereof for the offenses in imposing consecutive time. That's all three findings from 2929-14C4. The trial court engaged in the fact-finding process. Now, I will note that, as we pointed out on brief, the court makes the C4C finding at the hearing and imposes the C4B finding in its entry. To the extent that there is any kind of mismatch there, the court makes all three findings, and the court again makes three findings in its entry. But to the extent that there is any kind of mismatch there, a nunc pro tunc entry to correct that would be appropriate. However, in terms of the ability to impose and the appropriateness of the consecutive sentence finding in this case, the state believes that the court should affirm. The second assignment of error for this morning's purposes, the third assignment of error on brief, the restitution issue, unless there are any questions on the consecutive sentence issue. The restitution issue it really boils down to this issue of whether the court has to put in its entry language that the restitution ordered is joint and several. That's the issue in front of the court this morning. Does the court have to specifically provide in its entry that it's joint and several when it's clear from the record that it's being imposed in that manner, and because the language in 2929-18A1 says that a restitution order can be complete, that the court does not have to apportion restitution, and it's the state believes that because the clerk's office collects restitution payments, and as counsel's kind of referring, there's kind of this suggestion in criminal cases where prison sentences are imposed that victims aren't going to receive restitution anyways. I'm not sure what to make of that, but in this case, assuming that restitution is actually paid as ordered, I don't believe that it's inappropriate to allow the clerks to kind of keep track of how much has been paid so that the victims aren't double compensated, I guess is the concern here. Also, I point out in brief, and I'll note again this morning, that 2929-18A1 actually has a mechanism for this to be handled by the trial court. So in that sense, I'm not sure that the appellate resolution is really required in this case. The defendant or the victim, or really anybody, any of the parties involved, but the defendant specifically, could file a motion for modification under the statute. If he believes that there's somehow some issue the trial court should modify its restitution award, he can do so.
Does that relate to the amount or only to payment, specific payments?
The language of 2929-18A1 doesn't really distinguish, and so I think that there's at least a lot of good faith authority for the defendant to do that. It doesn't talk about, I think the statute specifically refers to both the amount, but also, I mean, there's nothing in the language saying that it's limited only to the amount. So I think that there's certainly, the language would tend to support the fact that the defendant could move the trial court for modification along these lines. The other thing I'll point out is the defendant never objected to this language at the sentencing hearing, so he's forfeited all but plain error on appeal, and he doesn't argue plain error. It's captioned, but it's not actually argued on brief that this is a plain error. And given that, the third district has held that the trial court does not have to apportion restitution between defendants, even though there could be joint and several liability. The third district, in the case of the state sites, State versus Klein out of the third district, said that we don't have to do it. We should let the trial court's decision stand, and if the defendant believes that modification is required, there's a process for him to do that. I'll point out briefly, we note on brief that post-release control in this case was imperfectly imposed. The burglary offenses in this case are offenses of violence under 290101A9. Because they're offenses of violence, it's actually a mandatory period of PRC as opposed to the optional period the trial court imposed. So pursuant to Singleton and 2929-191, we believe that the trial court should be required to correct the statutorily imperfect post-release control. Now, I guess that brings me back to the first assignment of error, this merger issue. And what I'll point out here is that there's really two potential issues of merger at play in this case. The first is whether all of the three burglary counts should have to merge together. And I think the response to that is somewhat simple in that they are alleged to have been committed and are admitted to have been committed on different days. And so in that sense, they are separately committed. They do not merge under 2941-25. The second issue for how these offenses are potentially merged is whether the burglary should merge with, or the theft should merge with the burglary. And as the state notes in its brief, in several places, the Ohio Supreme Court has specifically held with the burglary context in mind that once the trespass is complete, whether or not the underlying offense has actually been committed, the offense is complete. Bless you.
Thank you.
When you trespass into the occupied structure with intent to commit the crime, to commit any crime, the burglary is complete. The fact that you actually go through and follow through and steal the items you walk into the house to steal, or that you engage in the severe beating of the homeowner, as in most of the cases the state cites, right? The fact that you trespass into the structure with intent to commit a beating and then actually follow through and engage in the beating, those are separate offenses for which separate punishment may be imposed. The Ohio Supreme Court, in long-standing authority, both pre and post Johnson, and I understand that Ruff has kind of changed the Johnson landscape, but both pre and post Johnson, the Ohio Supreme Court was very consistent about this fact that burglary is complete upon the trespass with the requisite intent. When you actually commit a new crime, that is a new offense for which additional punishment may be imposed. They are not subject to merger. And that's State versus Frazier, State versus Lind, this court's 9th District decision in Lind. So for all those reasons, these offenses do not merge. The other thing I'd point out on the merger question is that there was no objection to the merger issue at sentencing. Because there's no objection, the defendant forfeited all the plain error. Although he captions, I believe, his assignment of error to assert plain error, there's no argument on brief as to why this would constitute plain error. So I think the court should overlook the assignment of error on that basis under State versus Sykes. Also, there's no real supporting authority cited on brief in this respect because all of the authority is opposite the defendant's challenge. Right? The Ohio Supreme Court, this court, other courts have all consistently, routinely, repeatedly held that this is not subject to merger. Unless the court has any additional questions, I would respectfully ask that the court affirm the decision below. Thank you very much.
Thank you. You have 5 minutes.
Thank you, Your Honor. Very briefly, as to the objection regarding merger, defense counsel in this case did file a lengthy pre-sentencing brief that specifically laid out the arguments for merger. I believe that argument was made at sentencing and is thus not subject to merely plain error review. As for the case cited by the state in regards to the restitution, I think that case actually gives us valuable guidance as to why we can't just leave this up to the clerks. The court does have some discretion to do some different things in the sentencing entry, and we can't let the clerks determine whether or not it's joint and several because, for example, in that case they ordered differing amounts, and in this case the judge could have said I want 50 in one, 10 in one, 15 in one. The court is allowed to do that, and the only way to provision for that kind of mechanism is if we make the court do it in their entry and don't just leave it up to the clerks. So I think the judicial discretion there actually speaks to why the judge has to do it correctly. And going to the larger issue as to the concurrent versus consecutive, where we're asking the court to show their work is not in explicating the findings, but showing their work under the order of consecutive. In this case, we have an order for consecutive that does not show how the court got there. We're not asking the court to then do a third level of analysis and explain that. We think it is sufficient if the court says, here's how we got to consecutive. And as for the contention that the court did address that in sentencing, I think the sentencing record is clear. If you read the entire sentence, as the sentence that the state cites to ends with, it does not seem that it is disproportionate to require that you have a custodial incarceration. The court talks about these things in a sentence that says that's why I'm ordering custodial incarceration, and then jumps to consecutive without proper consideration. And I think there is a requirement that they show something. We understand the magic words position, but at the same time, we don't allow courts to inquire as to a defendant at arraignment, did you do this thing? And allow the defendant to go, nah, I didn't do this thing. We're standing here today wearing ties. I mean, we do make requirements that you have to go through formal steps. There is some formality. It is not a completely informal, close enough is good enough process when we're utilizing the full power of the state in a way that the legislature has dictated, against the way that the legislator has dictated that close enough is good enough. I don't believe there's no limits on the close enough is good enough analysis to sending someone to prison for an additional 3 years or an additional 4 years. I think that asking the judge to explain that and at least the level required by the statute is fully appropriate. And for that reason, we would ask the court to reverse this, remand this for a new sentencing hearing consistent with the requirements of 292914, as well as to order the joint and several language be instituted in the entry.
Thank you.
Thank you, Your Honor.
Thank you both for your presentations. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, and you can look on our website.
Thank you.